Welcome back to our MD's I Law channel where every case is clear. If you are new here, I am Kritik and this is part 8 of our AIBE 17 previous paper analysis series. Today, we are diving deep into some of the most important questions from the AIBE 17 exam, breaking them down to help you prepare effectively. Whether you are gearing up for your exam or just looking to understand the legal landscape better, you are in the right place. So, grab your notes, and let's get started. 71st question is: who has the power of summary trial of a case? The correct option is D, all of these. Under the section 260 of Code of Criminal Procedure in India, the power to conduct summary trials is granted to specific magistrates. Summary trials are a type of fast-track trial for certain offences that are considered to be minor. They are intended to expedite the judicial process by simplifying the procedure and reducing the time taken to dispose of cases. The relevant provisions for summary trials are found in sections 260 to 265 of the CRPC. Note: in a summary trial, the maximum sentence that can be imposed by the magistrate is 3 months imprisonment. 72nd question is: which order of Civil Procedure Code deals with temporary injunction and interlocutory injunction? The correct option is B, Order 39. Order 39 of the Civil Procedure Code, 1908 deals with temporary injunctions and interlocutory orders. This order provides for the grant of temporary injunctions to maintain the status quo until the final disposal of the case. An interlocutory order is an order passed during the pendency of the suit, which does not decide the main question in controversy, but only a collateral issue. 73rd question deals with contracts. A is a tradesman in Ahmedabad, B carries on business in Delhi. B, by his agent Ahmedabad, buys goods of A and requests A to deliver them to the Western Roadway Transport Company. A delivers the goods accordingly in Ahmedabad. A may sue B for the price of the goods. The correct option is C, in either Ahmedabad or Delhi. This is because, according to Section 20 of the Indian Contract Act, 1872, the place of performance of a contract is the place where the offer and acceptance are made, or where the parties intend or agree to perform it. In this case, the offer and acceptance were made in Ahmedabad, where B's agent bought the goods from A. Therefore, A can sue B in Ahmedabad. However, A can also sue B in Delhi, where B carries on business, as per Section 20 of the Code of Civil Procedure, 1908, which allows a plaintiff to sue a defendant at the place where the defendant resides or carries on business. Therefore, A has the option to sue B in either Ahmedabad or Delhi. 74th question is: which of the following section of Civil Procedure Code deals with the concept of res judicata? The correct option is B, Section 11. Section 11 of the Civil Procedure Code, 1908 deals with the concept of res judicata, which means a matter already judged. According to this section, no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties, or between parties under whom they or any of them claim, litigating under the same title, in a court competent to try such subsequent suit or the suit in which such issue has been subsequently raised, and has been heard and finally decided by such court. This section is based on the principle that there should be an end to litigation and that the same matter should not be re-agitated again and again. Res judicata aims to prevent multiplicity of suits, avoid conflicting decisions, and uphold the dignity and authority of the courts. 75th question is: X, Y and Z are jointly and severally liable for 10,000 rupees under a decree obtained by A and Mr. Y obtains a decree for 10,000 rupees against A singly, and applies for execution to the court in which the joint decree is being executed. Which of the following option correct for Mr. A? The correct option is A, Mr. A may treat his joint decree as cross decree under Order 21 Rule 18. The explanation is as follows. Order 21 Rule 18 of the Code of Civil Procedure deals with the execution of cross decrees, which are decrees passed between the same parties and capable of execution at the same time by the same court. According to this rule, if the two sums due under the cross decrees are equal, satisfaction shall be entered upon both decrees. If the two sums are unequal, execution may be taken out only by the holder of the decree for the larger sum and for so much only as remains after deducting the smaller sum, and satisfaction for the smaller sum shall be entered on the decree for the larger sum as well as satisfaction on the decree for the smaller sum. In the given question, X, Y and Z are jointly and severally liable for 10,000 rupees under a decree obtained by Mr. A. This means that Mr. A can recover the whole amount from any one of them or from all of them in proportion. Mr. Y obtains a decree for 10,000 rupees against Mr. A singly and applies for execution to the court in which the joint decree is being executed. This means that Mr. Y can recover the whole amount from Mr. A alone. Therefore, Mr. A and Mr. Y have cross decrees for the same sum of 10,000 rupees. According to Order 21 Rule 18, satisfaction shall be entered upon both decrees and neither of them can execute their decree against the other. Mr. A may treat his joint decree as cross decree under this rule and inform the court of such payment or adjustment. 76th question is: A, B and C are copartners of joint Hindu family. They jointly execute a mortgage in favor of Y. Y files a suit against all of them. Summons is served to C but not to A and B. None of them appears and an ex parte decree is passed against all. A and B applied to set aside the ex parte decree. The decree will be set aside against. The correct option is C, A, B and C. This is because according to Order 9 Rule 13 of the Code of Civil Procedure, 1908, an ex parte decree can be set aside if the summons was not duly served or the defendant was prevented by sufficient cause from appearing in the court. In this case, A and B did not receive the summons, so they have a valid ground to set aside the ex parte decree. However, C also received the summons, but did not appear in the court. Therefore, C cannot apply to set aside the ex parte decree on his own. However, if A and B apply to set aside the ex parte decree, it will also benefit C, as the decree was passed jointly against all the copartners. This is based on the principle of joint liability and benefit of the copartners in a Hindu joint family. Therefore, the decree will be set aside against A, B and C. This is supported by the case of Nanda Dulal Pradhan and another versus Dibakar Pradhan and another, where the Supreme Court held that an ex parte decree passed against a joint Hindu family can be set aside if any of the copartners did not receive the summons. 77th question is: if someone lies before the court on affidavit, how it can be tackled by the advocates? The correct option is A. Perjury application can be filed. Perjury is the offense of giving false evidence or making false statements in a judicial proceeding. It is punishable under sections 191 to 203 of the Indian Penal Code, 1860. Section 340 of the Code of Criminal Procedure, 1973 provides the procedure for filing a perjury application before the court where the offense is committed or by a superior court. The court has to satisfy itself that it is expedient in the interest of justice to initiate an inquiry into the offense and make a complaint in writing to the magistrate having jurisdiction. The magistrate will then conduct the trial according to law. 78th question is: proclamation for person absconding shall be published as follows. First, it shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. Second, it shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides or to some conspicuous place of such town or village. Third, a copy thereof shall be affixed to some conspicuous part of the courthouse. Fourth, the court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper circulating in the place in which such person ordinarily resides. The correct answer is D. All 1, 2, 3, 4 are correct. Explanation. According to Section 82(2) of the Code of Criminal Procedure, 1973, a proclamation for person absconding shall be published in above 4 ways in simple terms. It shall be publicly read in some conspicuous place of the town or village in which such person ordinarily resides. It shall be affixed to some conspicuous part of the house or homestead in which such person ordinarily resides or to some conspicuous place of such town or village. A copy thereof shall be affixed to some conspicuous part of the courthouse. The court may also, if it thinks fit, direct a copy of the proclamation to be published in a daily newspaper circulating in the place in which such person ordinarily resides. This is done to ensure that the person against whom the warrant has been issued is made aware of the same and is given an opportunity to appear before the court. 79th question deals with appeals. Which of the following statement is incorrect? The correct answer is C. Second appeal can be on question of fact or law or both. This statement is incorrect because a second appeal can only be filed on a substantial question of law, not on a question of fact or law or both. A question of law is substantial when it affects the rights of the parties and has a bearing on the final outcome of the case. A question of fact is one that relates to the existence or non-existence of a factual situation. Whereas first appeal can be filed on any ground, whether of fact or law or both, as long as it challenges the decree or judgment of the lower court. First appeal can be filed in the district court or the high court, depending on the value and nature of the suit, as prescribed in sections 96 and 97 of the Civil Procedure Code. A second appeal has to be filed in the high court, as per section 100 of the Civil Procedure Code. 80th question is very simple one. As per order 6, pleading shall mean. The correct option is C, both plaint and written statement. As per Order 6, Rule 1 of the Civil Procedure Code, 1908, pleading shall mean plaint, a written statement. A plaint is a statement of claim in which the plaintiff sets out his cause of action with all the necessary details and particulars. A written statement is a defense in which the defendant deals with every material fact alleged by the plaintiff and also raises any counterclaim or set-off. Pleadings are statements in writing delivered by each party alternatively to his opponent stating what his contention will be at the trial and giving all such details as his opponent needs to know in order to prepare his case or answer. Thanks for tuning into this part of our AIBE 17 analysis series. We hope you found the insights helpful for your exam preparation. If you enjoyed the video, please give it a thumbs up, subscribe, and hit that notification bell so you don't miss the next part in the series. Share your thoughts or questions in the comments below. We love hearing from you. Until next time, keep studying, stay focused, and good luck on your journey. See you in the next video.